Hello, everyone, and good afternoon. Thank you for joining our Impacts of COVID-19 on the Renewable Energy Industry, Recent Legislation and Effects on the Supply Chain and Construction webinar. Before we get started on today's presentation, I'd like to go over a few housekeeping items. For those of you that may have questions about any of today's topics, we invite you to type them into the Q&A widget on your screen. We will try our best to answer all questions at the end, time permitting. However, if we do not get to all of your questions today, we will follow up with you via email. Please note the presentation portion of this webinar was pre-recorded late Friday afternoon. As an added reference, we encourage you to visit our Coronavirus Resource Center page on Foley.com, where we offer insights from across Foley's many practice disciplines on what companies can do now in response to the legal and business impacts of the coronavirus, and how they can prepare for the future. An index of articles can be found in the resource widget located on the bottom left-hand side of your screen. To receive coronavirus-related alerts in real time, please visit the Resource Center page to subscribe to our mailing list. If you experience any technical difficulties with your webinar platform, please refresh your browser or see the webcast help guide on your screen.
Got it. Thank you for joining us, and welcome to Foley & Lardner's webinar addressing the impacts of COVID-19 on the renewable energy industry, including a discussion of recent federal legislation and the effects of the currently evolving pandemic on renewable energy project supply chain issues and construction issues. We are clearly in the midst of a set of unprecedented external shocks to the energy industry, and both the federal government and individual states are taking dramatic and bold steps to address this crisis. Significant announcements are occurring on a daily basis that have really dramatic impacts on the industry. Now, we've pre-recorded this webinar so that we can answer questions in real time and provide an update as we go through the webinar, but wanted to let you know that. The intent of this panel discussion is to bring some clarity to a few issues that have been evolving in recent days. This webinar is part of a series of alerts and webinars provided in coordination with Foley & Lardner's Coronavirus Resource Center, or CRC, which has been tracking the impacts of the coronavirus and the response to it and its impacts on individuals and businesses in a broad range of industries on a daily basis. And we'd recommend referencing that center to anyone who's interested in those broader issues related to these topics. The website for the CRC is listed on in the webinar materials in the presentation. This is Darren Lauder speaking. I'm a partner at Foley & Lardner in the Energy Group based in our Washington, D.C. office. My practice focuses on assisting developers, lenders, and investors in the development and financing of renewable energy projects, generally in the U.S. and with an emphasis on the solar industry. Also on the panel is John Eliason, and he'll introduce himself in a few moments, and Vanessa Miller, who is a litigation partner and chair of the Detroit office's litigation department. She focuses on manufacturing breach of contract and warranty disputes and other supply chain issues. And I want to pass the baton to Vanessa to further introduce herself, and for her then to briefly introduce John Eliason, who will begin our first segment addressing recent legislation, specifically some provisions in the CARES Act, and some additional legislative responses to the coronavirus pandemic. Vanessa?
Thank you, Darren. Hi, I'm Vanessa Miller, and in addition to the information that Darren provided about my supply chain background, I'm also the co-chair of the firm's Supply Chain Solutions Group and one of the leads of Foley's COVID-19 task force. By virtue of being in Detroit, I have a number of automotive and other manufacturing clients with extremely sophisticated global supply chains. I specialize in supply chain and manufacturing litigation and international arbitration, but I also do a fair amount of commercial counseling on commercial transactional issues impacting clients' global supply chains. And now John is going to begin the presentation with an update with legislation.
Great, thanks Vanessa. So this is John Eliason speaking. I'm a partner in the DC office and the co-chair of our energy industry team. My practice is spent representing tax equity investors and developers, lenders, manufacturers, pretty much all aspects of the players in the renewable energy space in transacting in solar and solar and wind. Being in DC with Darren also has given us kind of a nice view of kind of what's going on down the street in the nation's capital and seeing kind of things that are going on there. One of the things I want to talk about today on the legislation is really kind of the things that are in the CARES Act, which is the provision just recently, the act that was just recently passed last week. What you'll note here is there's nothing really specific to renewables here, but there's several items of importance that that are really applicable to all businesses in our space. So I wanted to just focus on those items. Here's a list of the things that we're going to be talking about today. I suggest that this would be helpful for printing out in the future the entire presentation, so that so you'll see what we covered. So what I talk about is the Paycheck Protection Program. This is a program that's been getting a lot of press lately. It's a loan program in which there's $349 billion available from the government. It's available for small businesses. So these are businesses employing less than 500 people. And the program provides low interest loans up to a maximum of $10 million. There's specific things that the loans are intended to cover. The real intent is to cover payroll, and to get kind of those determining the maximum amount of the loan is highly dependent on kind of what your payroll is. There's favorable features about the Paycheck Protection Program. There's no personal guarantees, there's no collaterals required, and payments can be deferred for 6 months. Best of all, as long as you're using the money for certain operating expenses during the first 8 weeks after the loans originated, there's loan forgiveness available. What's important there is that you're using the loan proceeds for the right things. There's been a few launch issues, as you might not be surprised. Kind of rolling out over $2 trillion of stimulus spending has some particular hurdles. With respect to the Paycheck Protection Program, the CARES Act provides that there could be a maximum of 4% interest charge on the loans. Last Tuesday, the Trump administration reduced that to 0.5%, and then the SBA then in its guidance that came out on Thursday raised it to 1%. So that's what the rate's going to be. And then the other thing is that they clarified that loans would have a two-year maturity. So the other thing that mention here is that as of Friday, meaning today, the day that we're making this recording, banks were waiting to make sure that they had a full understanding of the guidance. So while there's been a tremendous interest in this program so far, banks haven't started providing these loans. So we'll see how things go in the next few days as those lenders start making these loans available. Other important thing to remember is that, as shown on the slide, the CARES Act says that the Paycheck Protection Program is available until June 30th, 2020. But we've been hearing that this money is going to be used up very, very quickly. So if this is a program that's of interest to you, we recommend that you try to reach out pretty much after you hear this webinar and talk to your SBA lenders to get your application in to make sure the money is available.
John, this is the loan forgiveness. So that aspect of this program essentially turns the loan into a grant. Is that a competitive loan forgiveness? Is that kind of just programmatic built into the process? and do we know much about that how that's going to work yet, or is that all still out in the future?
It's not. It's on application, right? You'll have to make a certification of what you've basically spent your proceeds on, but not. It's not competitive. I think we'll know more as the lenders start rolling out their individual programs. All right, so the next thing I wanted to talk about briefly was the Economic Injury Disaster Loan Program, or the EDIL program. This is also a program that's limited to businesses with fewer than 500 employees and provides loans up to $2 million. This program actually predates COVID-19, but it's been modified in the CARE Act. So lenders are used to loaning under this program. So with respect to the COVID-19, to be eligible, businesses must be either directly affected by COVID-19 or serving businesses that were directly affected by COVID-19, or other businesses that are indirectly related to those businesses that are likely to be harmed. So when I kind of think about like the net that they're casting here, it sounds like pretty much everybody could fall within these eligibility pools. Funds from an EDIL loan can be used to pay fixed debts, payroll, accounts payable, and other bills that could have been paid had COVID-19 not occurred. Important thing to remember is that EDIL loan proceeds can't be used to pay down a longer-term debt. They're really used for those specific operating purposes. A COVID-19 EDIL loan won't be forgiven like a Paycheck Protection Program loan, and the application is more complex, but it is streamlined by SBA standards. COVID-19 related EDIL loans are available until the end of 2020. And another thing you see on the slide is that I wanted to mention is that there's an emergency grant of $10,000 of up to $10,000 available to applicants of the EDIL loan, even if they don't get the loan. So if you don't get the loan, you can get a $10,000 advance paid within 3 days of applying. But if you don't qualify for the loan, that money does not have to be returned. With respect to that advance, there's only $10 billion that's been set aside for that. So it's expected that those advances will go very, very quickly. So if that is something that's of interest to you, I encourage you to reach out as soon as possible to obtain those proceeds. One important thing to remember from both this loan and the prior one that we talked about is that you're making certifications to the SBA, which is the federal government, and you're the borrower, so you're at risk if those certifications aren't correct. So this is certainly a situation that you don't want to find yourself being accused of trying to defrauding the government for loan proceeds. Something to think about. Okay, if you're not a small business, the CARES Act is providing assistance to large businesses. So these are businesses with between 500 and 10,000 employees. The focus in the press is that large business help is for helping airlines, but the CARE Act does not limit themselves to those businesses. It's really it's focusing on businesses that have not already received adequate economic relief from other programs under the CARES Act. There's only a few details with respect to the help for large businesses that have been out so far. Those details are really kind of focused and designed to prevent abuse of the program. Rather than spending more time looking at this, I'll suggest to you that if you're a large business seeking help here, we encourage you to get your attorneys involved, as these are going to be more complicated than the other loans we've talked about.
John, so as compared to the Paycheck Protection Program or the Economic Injury Disaster Loan Program, it looks like the restrictions on the large businesses kind of highlight the lack of restrictions on the other two programs, and those are pretty broad programs in comparison. Is that a fair reading?
I think so. The help for large businesses, this is the program that's being administered by the Department of Treasury, and they really haven't created the rails around that program yet. I mean, they're seeking to do that as we speak, but it just hasn't happened yet. So yeah, I think that there's a lot when there's so much money is involved. There's certainly concern that money will go in the wrong places. So yeah, I think that I think we'll end up seeing kind of heightened restrictions in that area.
Got it.
Yeah. So moving past the loan provisions, I wanted to just focus on some other things that several are tax related, but are likely to be of interest to several of the folks dialing in. There's an employee retention credit that's available by the CARES Act. So basically this is intended to keep employers from firing employees during this period. The tax credit is equal to 50% of qualified wages. Qualified wages is a defined term in the Act. The way to look at it is that these are kind of like what you'd expect kind of ordinary W-2 wages to be, and the credit is capped at the employer's portion of the Social Security and employment taxes, which is a 6.2% 2% tax. If you're getting a loan under the Paycheck Protection Program, then employee retention credit is not available. Okay, next, deferral of payroll taxes. So this involves the same 6.2% tax that I mentioned in the last slide. Pretty much all employers are provided the ability to defer the payment of their payroll taxes and without any penalties at all. So 50% of these taxes that were due for the period between March 27th and the end of 2020, 50% of those taxes will be due at the end of 2021, and 50% of those taxes will be due at the end of 2022. Once again, this is a program this provision is really intended to allow employers to kind of keep more cash on hand as opposed to paying it out. Okay, so then we have a modification for corporate net operating losses. So to describe this one, I need to give you a little bit of background. So before 2018, C corporations were permitted to carry back net operating losses to prior tax years. This means that if the taxpayer had a loss in a current year, it was able to file a refund in a prior year to basically get that money back. You could also carry those losses forward to a future year. So that provision changed at the end of 2017 as part of the Tax Cuts and Jobs Act. The Tax Cuts and Jobs Act eliminated the ability to carry back losses beginning in 2018. Unused NOLs could be carried forward indefinitely, but then could only offset 80% of a taxpayer's income in that future year. So the CARES Act amends the treatment of corporate NOLs. So for tax years 2018, 19, and 20, it allows losses to be carried back 5 years, starting with the earliest year. So in other words, if you had a loss in 2018, you could carry it back to 2013. That's really helpful because corporate tax rates prior to 2018 were higher than they are now. So they were 35% prior to 2018, and now they're at 21%. That means that carried back losses will provide a bigger benefit if they're carried back to a tax year prior to 2018. With respect to carry forwards, the Act also suspends that 80% limitation for the pre-2018 NOLs, as well as for 2018, 2019, and 2020. That limitation would apply for losses after 2020. The idea is that at that point, this part of the CARES Act kind of falls away. Another item to just spend a couple minutes talking about are the loss modifications for non-corporate taxpayers. So there's some retroactive relief for certain, with respect to certain disallowed losses. They're basically allowing businesses to claim deductions for excess business losses, which are basically trader business losses in excess of trader business gross income plus $250,000, or $500 in the case of a joint return. The takeaway here is that if you're a non-corporate taxpayer and you had losses that you were limited and were not able to claim, chances are you'll be able to take them now as a result of the CARES Act. Okay, and then the CARES Act also modifies the business interest limitation. So starting in 2018, Congress put in place a 30% taxable income limitation, which basically suspends interest deductions in excess of that amount. The CARES Act increases that limitation to 50% for 2019 and 2020, and then also provides some special rules to loosen up losses for partnerships, which I think for purposes of this presentation we can skip. Okay, so that was a really quick overview of important items in the CARES Act that I think are of interest to the industry. And there's some thought about, like, well, what does the future hold? The CARES Act represents a phase of stimulus intended to rescue the U.S. economy and keep people employed. It really, that's the purpose of it, and that's kind of why you see so much haste right now in getting it passed and trying to get these provisions implemented. Congress will be considering whether to adopt another phase of stimulus when they get back from recess after April 20. That new package will be the intent is to stimulate economic rebound. So what we've already heard in this space is that the House leaders want to put in place a stimulus package with a big focus on infrastructure. They're throwing numbers around in the nature of $750 billion. And the Trump administration is supportive of this in concept, but is actually throwing around larger numbers, closer to $2 trillion. Senate leadership is less excited about another stimulus package before they see how the CARES Act is working out. But in any case, I think that if we're going to see the renewables addressed specifically, it's going to be in this next stimulus package. Trade organizations are pushing for extensions of tax credits, possibly bringing back something like the 1603 cash grant program. I don't think we quite know yet what it's going to look like, but these are the things that people are discussing. I suspect also that the oil and gas industry will be looking for help as well. They're being impacted badly due to both a drop in demand, right? We're all sitting at home, we're not using our cars and not buying gasoline. But then also that the price was already really being subject to attack by the Saudi Arabia and Russia basically declaring a price war on the price of oil. So I'm thinking that for the House to get on board with incentives for the oil and gas industry, I think it's likely that we'll see assistance provided to renewables. And Darren and Vanessa, if you have any thoughts about potential future legislation.
I understand that although Congress is in recess, the staff, a lot of the staffers are in Washington working on exactly those issues. So I think those are all being teed up. The exact substance, I think, as you pointed out, still remains to be seen exactly how it's going to be handled. But we certainly heard some folks explain that in the CARES Act, they tried to stay away from those kind of sector-specific issues and focus on retaining employees, as you pointed out.
Yeah, and I think that the reason for that is that it's going to be more of a partisan battle, I think, and the concern is that the CARES Act would get held up from discussions like that. Okay, everybody, I'm gonna pass the baton back to Vanessa now, and she'll be talking about supply chain strategies and considerations to manage the COVID impact. Vanessa?
Thanks, John. The focus of this portion of the presentation will be on manufacturers in the renewable energy industry and of the various orders and regulations. Look at the locations where your critical suppliers and where your end customers operate, as well as where the construction projects are occurring, because each of these orders is going to impact the inputs and then the ultimate output and whether you're able to continue performing. So consider the implications of the executive orders and regulations across your global supply chain. Look at the manufacturing footprint. Who are the company's critical suppliers? Which customer contracts are in jeopardy of not being fulfilled, not being completed by the required deadline? And then where are the construction projects located? There's different limitations on construction projects across various states, and Darren's going to discuss those in detail in the next section of the presentation. But the most important inquiry and the common theme across all the U.S. locations that we're seeing is, asking the essential question, do my operations qualify as essential? Do my operations support what is termed essential business or an essential infrastructure function? Now, although most renewable energy projects are exempted and considered as essential under both the executive orders and the federal CISA advisory guidelines, that's not an across-the-board green light or pass to continue all operations. If one operation, project, or function qualifies, then you need to stop and say, okay, are the others similar? You can't, it's not just an umbrella to keep operations open and full. So most manufacturing companies are going to need to look at this and analyze this on a location-by-location, manufacturing line by manufacturing line basis, even down to the part-by-part. It's really a highly specific fact inquiry that needs to be done through the team that the company's pulled together, looking at the applicable orders and, of course, the related risks. Where the line should be drawn, really that's ultimately a business decision that needs to be informed by legal advice and risk assessment, which, as we're seeing, is changing daily. Next,
Vanessa?
looking at, yes.
Sorry, just a question on a couple of the points there. So on the locations, this sounds like a more detailed analysis of supply chains than maybe most people, at least outside of the automotive industry, are used to doing. This is not just an end-use product, it sounds like. This is kind of trying to understand where the components came from to see what kind of delay you may be dealing with, what kind of issues may be affected, and who may be affected. And I heard the line-by-line example of if the factory makes healthcare equipment but also makes toys, you can't keep working on the toys. You can only keep working on the healthcare equipment. I assume that's kind of the issues that you're describing on the line-by-line. But this sounds like pretty in-depth analysis of the supply chain compared to kind of business as usual.
That's correct, and it really does need to be, because just because you've made the decision, and I'll get to that in my next slide, just because your company has made the decision that it is essential or that its product is essential, have your suppliers made that determination? Have your customers made that determination? There's a lot going on upstream and downstream in the supply chain that needs to be taken into account before the company can really make an informed decision and determine whether or not it is going to be able to perform. Next, communicating with critical suppliers and customers. And this goes to Darren. You need to be aware of what is happening across the entire supply chain. How are your customers and suppliers interpreting their operations under the orders? is there room for a potential battle regarding interpretation and application of the orders? When the response team identifies those mission-critical materials and parts looking all the way downstream, companies need to consider proactively reaching out to those suppliers, whether it's raw materials or subcomponents, to determine what level of inventory they're carrying, what may be in short supply, do they have anything available to ship, are they needing to allocate across multiple customers, and what actions the suppliers themselves are taking to prepare or minimize operations or shut down. And then even considering parts that aren't in your own supply chain is going to be important, especially for construction projects. If another unrelated supplier outside of your supply chain has shut down and cannot obtain materials, it could halt an entire construction project. You need to be aware of which projects aren't going to be going forward because of something outside of your control. You might not want to allocate your resources if you don't have full access to the typical amount of resources to a project that's going to be ceased anyways because another supplier has shut down.
Hey, Vanessa, I think that another thing that people need to keep in mind is that as you learn more information about your projects, make sure that you're keeping other parties informed, right? Is that if you have a construction lender involved or an investor or something like that involved, now's the time to make sure that they kind of know what's happening and why, so that they can plan as well.
Yeah, we're seeing a lot of preliminary notices that are not necessarily notices of force majeure, but notices of delays and potential negative impacts. And I think the lenders certainly appreciate that. I know the investors are in the same boat.
Yeah, let's talk about that next. So the next point is reviewing the purchase and supply contracts to what constitutes force majeure, what the rights are, and what requirements may apply. Companies need, as a starting point when they figure out with their critical supply chain, review the contract, look at the contract terms. You need to understand the rights, not just in the contract itself, but there's also implications under common law and defenses you have under common law. All of a sudden, force majeure is such a common term. Before this pandemic, I've always cared a lot about force majeure, but not many people did. Before this pandemic, most companies didn't spend a whole lot of time focusing on the force majeure provision. It was just a cut and paste across multiple contracts that people inserted, whether the company was the buyer or the seller, just copied it from another contract. What is force majeure? Literally translated, it means superior force, and it is an event, typically an act of God, act of government, or other circumstance that prevents a party from performing its contractual obligations. Some common examples that we've seen in the past are floods, fires, or hurricanes that prevent the seller or the supplier from manufacturing or timely delivering parts or services. The key is that it really needs to make it impossible to perform, not just more expensive. And we saw that play out with the tariffs. Sellers would say, well, I'm going to rely on my force majeure provision. This has become, so it's too expensive. I'm losing money on this. And courts looked at that and said, no, you're still able to supply. You're just not making a profit. That's not force majeure. But this is different. And force majeure provisions typically, for the most part, benefit the seller because it is the seller that is unable to perform its contractual obligations to manufacture parts or provide services. At a high level, companies need to assess their rights under contract law. Are they prevented from performing their contract obligations as a result of the government order, the quarantines, et cetera? When we are being asked whether contractual force majeure provisions apply. And typically, if it contains the term act of government or the broad catch-all phrase, which most do, or other circumstances beyond a party's reasonable control that prevent performance, then that likely is going to be deemed to qualify as a force majeure event, as long as it actually prevents performance. The executive orders, to the extent the executive orders prohibit performance or if it prohibits or prevents one of your sub-suppliers or service providers from providing you the goods or services needed to perform your own contract obligations. So there's really two different ways in which it could play out. Case law before this pandemic is pretty limited on whether or not pandemics can be force majeure. This is really the first time we've had a global issue that has been this impactful on supply chains. But I think we're going to see a lot more courts interpreting force majeure provisions in light of COVID-19 and its impact. And I do expect that courts, for the most part, are going to interpret force majeure provisions quite broadly. And these are the exact type of circumstances where a party is prevented and should be excused from performance if it has a supply chain issue or if the executive order outright prohibits the project from going forward, the manufacturing from going forward. Okay, so what about contracts that don't have force majeure provisions? Well, there's also the common law doctrines of impossibility, commercial impracticability, which is codified in the UCC section 2-615, and then there's also the doctrine of frustration of purpose. Again, these are doctrines that really, and defenses that aren't often used, and there's not a lot of recent case law on them, but I think after this there's going to be. And courts are going to look at this situation and how extraordinary it was and determine whether or not the seller or service provider should be excused from performance, such that it's not a breach and no damages can be recovered, absent a separate penalty provision in the contract. So these contract provisions and related rights and obligations do vary greatly, but I think there's going to be some common themes once the dust settles on all of this, and you'll see these defenses and force majeure provisions being relied on. One thing to be aware of is many contracts have a right for the buyer, the customer, to either terminate a contract after a certain number of days have passed and performance hasn't been resumed if the supplier exercises force majeure, or they can terminate outright for convenience for any reason at any time. So it's just important to be aware that the time starts ticking once the force majeure notice is officially sent. Now, Darren mentioned a situation, and we've been seeing this a lot, where there's sort of what I call a preemptive force majeure notice that has been sent. And the notice doesn't actually declare force majeure or impossibility. It just starts to kind of alert customers to a potential situation and says there may be an impact because of COVID-19 and we may have delays in delivery. And then it promises to update the customer if or when performance becomes impossible. Questions that we get are, should these type of preemptive notices be sent if I don't have an issue yet in my supply chain? I think the answer is if you have reasonable concern that performance or your ability to perform under the contract is going to be impacted, then typically it's not harmful to provide this type of notice as soon as you have concerns, because you'll be able to point to it down the road, unless there's a concern the customer is going to elect to terminate for convenience. Next issue. How does all of this work together in manufacturing? So the executive orders issued by states, counties, and cities do not mandate businesses defined as essential business or infrastructure. They don't require them to stay open. They encourage those businesses to stay open. To the extent that the business ties to an essential need, healthcare, food, medical supplies, etc., the company still needs to make a determination as to whether they want to remain fully or partially open to ensure the supply of critical goods and services. And then as we've seen, additional precautions need to be taken under the orders in compliance with the CDC's recommendations. So if the executive orders do not list your company, then the facility should be shut down. Or operations need to be minimized and streamlined to be only those that are essential. And then force majeure notices will need to be sent as soon as that determination is made. Now, if the executive orders do list your type of company, or your company supports the essential businesses, and there's a position to be taken that your operation should continue, subject to the other requirements. You need to ask, are the volumes even going to be the same? Probably not. Many industries, volumes are dropping significantly and orders are going down. So other important considerations, looking at your raw materials, those available downstream, to determine if your own suppliers and service providers are going to be able to support your ongoing production, or if you need to declare force majeure because of their closures. And then what about other subcomponents or suppliers needed for the project? You need to be aware of what is happening, as John mentioned earlier. You need to be aware of what's happening, communicating about that. Is labor even available? What about the workforce? There's employee safety considerations set forth in all of the executive orders. Many have mentioned employee morale and how employees are perceiving their company's decisions that they are essential. There's a number of whistleblower claims that we're hearing about where employees are contacting local authorities and saying, we don't think that we're essential, we want you to come shut down the company. So a lot of manufacturers or other project owners are looking at ways to incentivize their workforce, really ensuring that they alleviate their concerns about social distancing, et cetera. And some have even discussed sort of an additional fee that they're paying on an hourly basis or a bonus type fee, given that they're requiring workers to come in despite the hazards of COVID-19. So what happens when operations resume as normal, which is the next topic? We're all waiting for that and hoping that it's sooner rather than later that operations will be back up and running at 100%. Manufacturers are waiting anxiously to see when the switch is going to flip back on and they can go back to running all of their lines with all of their employees. But we know that it's not that simple. You can't just go from 0 to 100%. There is a ramp-up period. And there's also requirements under the Uniform Commercial Code and common law that manufacturers, when they are trying to ramp back up, will engage in a reasonable allocation of available resources when they are providing available inventory and materials to their customers. Now, in the renewable energy industry, there may be some additional considerations and concerns about these allocation type requirements because it's very different from just providing standard inventory, for example, in the automotive industry, in that if you don't have 100% of the requirements for a particular project, the project likely cannot go forward. And there might also be penalties built in for certain projects or the inability to qualify for tax incentives if certain construction projects are not completed in 2020. So we expect a lot of deference to be given to the particular company as to how it's going to allocate available resources when manufacturing goes back to 100%. And it's going to be considered on a case-by-case basis. However, it's important to note that if a customer learns about or takes issue with your company's decision as to how to allocate during the ramp-up, there might be a dispute down the road. In summary, these are just some steps that companies can take to address impacts on the supply chain and mitigate certain risks. Now Darren's going to walk through some recent executive orders and their particular impact on construction.
Thank you, Vanessa. So we've seen, as Vanessa mentioned, we've seen a number of states that have imposed various restrictions. In fact, most of us are probably living under those restrictions. I know in the state of Virginia, where I live, our governor has imposed essentially a stay-at-home order through mid-June, June 10th. The scope of those have varied widely in terms of how they've restricted commercial activity or how they have affected construction efforts. and they're evolving on a daily basis. I was just on a call listening to restrictions in New York from NYSERDA was walking through how those would impact the renewable energy industry. We know of over 30 states that have issued those orders that have some commercial impact. Some states have addressed this by ensuring that localities can't supersede the state restrictions, or that they cannot have orders in place that would inadvertently restrict the ability of essential industries to operate. Other states have listed the industries themselves. We've seen some pretty extreme or stringent restrictions in a number of states, New Jersey, New York. Again, Virginia is similar in many ways. And then the states have listed how they are categorizing essential versus non-essential activities. So even if entities are allowed to operate, there are still typically social distancing requirements imposed. And we're seeing these requirements ratchet up in intensity. So a number of gathering orders that described what types of gatherings would be restricted started with no more than 100 people, then it was 50, then it's 10. Same thing with workforce reductions that need to move to telework. It started out with 25 or 50% reductions and then moved to 100% reductions. And so each state has grappled with how to determine what businesses are essential. There have generally been two approaches. So one is to refer to the Department of Homeland Security's Cybersecurity and Infrastructure Security Agency's guidance, what we call CISA, and Vanessa referenced them. They issued guidance on March 19th that has since been updated and clarified in terms of a number of industries, including renewable energy. And a lot of states are referencing that guidance. Some states have come up with their own list of what constitutes essential or critical industries and the workers for those industries. So this list, this is not an exhaustive list. This is of a number of the states that are kind of most heavily involved in renewable energy or that clients have asked us to keep an eye on. And you can see the list of states that refer to the federal guidelines, what we call the CISA advisory, that lists a number of industries, including renewable energy industries, that are considered essential or critical infrastructure industries. But you see a similar number of states that have come up with their own list of industries. Arizona, Connecticut, Illinois, Massachusetts, New Jersey, New York, Oregon, and Pennsylvania all have published their own list of what things are considered to be essential or critical in terms of whether they would then be exempt from restrictions on commercial industries, essentially subject to various shutdown orders. We mentioned Pennsylvania. You'll see them in both columns because they have a general restriction on construction, but if you are listed in the CISA advisory as being an essential critical infrastructure industry, then you can apply for a waiver, but only until Friday, April 3rd at 5 p.m. So there's kind of a surprising number of state-level standards that have been determined on a state-by-state basis. And while those may be similar, they have different rules and different guidelines that are imposed. So the CISA advisory, we're kind of living through the result of the federalist system that we have. We have federal guidance that many states are relying on, but is not mandatory. And then we have states that many of whom refer to that guidance because it's fairly well organized and clear. So the energy industry generally was designated as a critical infrastructure industry under the CISA advisory. And on March 28th, that was issued on March 19th. On March 28th, there was updates. There were updates provided, and in the updates, there were some important distinctions made with regards to energy. And the initial references focused really on the existing infrastructure for utilities and energy and power generation, transmission, and distribution to make sure that facilities could be operated, could be maintained, to keep the electric infrastructure, for example, in place, and other utility infrastructure. The additions clarified that essential critical industry workers include those supporting the energy sector. It includes renewable energy and those in construction, manufacturing, maintenance, monitoring, logistics, but also those who are involved in development and expansion. So as a general note, the development is going to be broader than construction. We heard the example of the need in some cases to negotiate directly with landlords in certain circumstances that might be difficult to do remotely. It could be done safely, directly, but difficult to do remotely. So that was a helpful clarification. I'll give you we'll walk through quickly two examples of states that have restricted construction significantly. The first one is Pennsylvania, and from their early announcements, they were very clear that construction generally is not permitted under the shutdown order. They then had some updates that determined that if you do fall into the CISA advisory categories, this was after the original shutdown order or shelter-in-place order, that you could apply for a waiver. Again, those were they were flooded with those waiver requests, and the deadline was published as Friday, April 3rd at 5 p.m. Which as of this recording, I think is in 5 minutes, and as of the presentation will be in the past. That is probably the most restrictive.
So there's still time. Is that what you're saying, Darren?
There's still time. That's right. That's probably the most restrictive policy, and that was in place kind of from the beginning. They were really a notable exception. The other example is New York, which is an example, and we were talking as a group of panelists a little earlier about how we're seeing these standards ratchet to become more stringent over time. And so this is an example of that. On March 20th, the initial order exempted construction activity overall from the restrictions on the shutdown restrictions on commercial activity in New York. And on March 29th, it then exempted only certain categories of construction. So there was guidance given that referenced utilities initially, but not much other detail. And then there were some follow-up FAQs issued which provided some detail and seemed to suggest that there were categories. For example, those that supported medical facilities, low-income housing, or homeless shelters as being critical infrastructure. But in discussions with the folks from NYSERDA, they were essentially saying that is really only if those utilities are required for them to operate. So if there was an on-site generation system that's critical to their operations, and that's what's being either built or maintained or operated, that would qualify. But if it's a community solar project, for example, where they're going to get a bill credit, they'll get a benefit, but they can still operate without that being constructed or completed, that probably would not qualify. So even in the exemptions, they are discussing being pretty, interpreting those pretty narrowly. So I think that is indicative of what we're going to see, that as the number of cases continue to expand in various places, that the standards will probably continue to tighten as we've seen them do in the last week, and this is really going to be a day-by-day exercise in understanding where we are in the process.
Yeah, Darren, I find it interesting that that's coming out of New York, right? New York is leading the country in cases of COVID-19, and as I think we're all kind of viewing, it's inevitable that other states, they might not catch up to New York, but the cases will increase. Is that whether states will kind of look to kind of like that more restrictive view of essential business that New York has done, and use that as an example.
Right. Well, and they're certainly discussing this as a pause and focusing on the fact that the more restrictive that we can be early on, the shorter period the pause should have to go forward. But there's so little information now, it's really just following this on a day-by-day basis and recognizing that if you're in other states, you probably should be prepared for a temporary shutdown, even if it's not in place at the moment. Just as prudent planning and as what Vanessa was describing, the supply chain probably needs to be undertaken in the construction process as well.
Yeah, those are all great points.
And I think this kind of ends our presentation portion, and we'll move into a few minutes of Q&A.
We hope you found this presentation insightful, and now we will transition into our live portion. Darren?
Thank you. We appreciate you joining us today. We did want to give a couple of items of updates. Over the weekend, some guidance was released for the SBA loan program, some FAQs on the Paycheck Protection Program. And there have been, we've seen some feedback from some of our clients that have received the funds already. So that program is moving forward. We're seeing some encouraging signs on that front. We also are continuing to update on a daily or near daily basis a number of the alerts, including those related to renewable energy construction restrictions in states and the orders that have been issued for those. So if you keep an eye out on those alerts, and the links to those pages have frequent updates reflecting the new orders that have been made on each of those. We would also remind everyone that over the next 2 weeks, we will be doing some webinars jointly with InfoCast. There's one this Thursday at 1 p.m. Eastern Time that will be moderated by our partner Jeff Atkin, and that will include Kathy Grover from Luminate, Mike McDonald from Zions Bank, and Johnny Tall, president of DEPCOM Power. They will be addressing in-depth review of those folks' experience with managing contract and supply chain disruptions. So there will be a little more detail and a little more kind of boots on the ground focus on that one. And then the following Thursday, so that will be the 9th, this Thursday, and then the 16th will be another panel moderated by our partner Tom Hoffman, and that focus will be on renewable energy financing update, focusing on what has changed and what hasn't in financing renewables. And that will include panelists such as Jitu Balchandani from BlackRock, Ralph Cho from Investec, Andy Redinger from KeyBank, and Darren Van Hoff from US Bank. So over the next 2 weeks, there will be some additional panels and webinars that our Foley partners will be moderating in conjunction with InfoCast. Keep an eye out for those if you haven't seen the invitations yet. We appreciate you joining us. This concludes our webinar and Q&A today. As a reminder, today's program is being recorded and will be available on Foley's website in the next few days. At the conclusion of this program, a questionnaire will appear on your screen. We'd appreciate it if you could take a minute to provide your feedback on that. We'd like to know your thoughts as it helps us shape our programs going forward. Thank you again for your participation and hope everyone stays safe and well. Have a good day.